Good afternoon, everyone. My name is Andrea McAvoy. I'm the Director of Client Services here at UC Berkeley's Office of Intellectual Property and Industry Research Alliances. Thank you for attending today's Talking Tech Transfer, Patenting and Licensing IP Fundamentals session. It's one of 6 webinars that's offered by IPIRA this fall on intellectual property, industry research alliances, SBIR's TTR grant funding, and other topics. If you create or manage research data in your work, you may also be interested in a series of webinars that's hosted by the Berkeley Research Data Portal. Deborah Summers, who is our Marketing and Communications Director, will be adding more information and links in the chat to register for these events. Following this webinar, watch for an email from her providing many of the links and resources being shared in today's session. If you are a UC Berkeley faculty member preparing for a promotion or tenure conversation, you may be interested in requesting IPIRA's new Innovation and Entrepreneurship Activities report. It provides information on I&E activities tracked by our peer divisions, the Office of Technology Licensing and Industry Alliances Office. Faculty can learn more and make a request by visiting our website. Today, we'll be hearing from Laleh Shayesteh, who is IPIRA's Director of Intellectual Property and Administration. Also joining us is Eric Geigerich, the Director of Industry Alliances Office. This webinar is conversational in nature, so feel free to unmute yourself to ask questions or type them in the chat. This session is being recorded and will be available on IPIRA's YouTube channel. If you have a topic or question you'd like to remain confidential, please ask Laleh after the recording ends. And a brief survey will appear when the session is over. We appreciate your completing it. Doing so help us identify new topics. To get us started today, I'm going to post a short survey. Your answering it will help us know who's here and your level of engagement with IPIRA. So you should be seeing that on your screen now. Okay, well, great. I'll give it one more second. All right, we've got 95% participation. Thank you very much for that. All right, Laleh, the floor is yours.
Awesome. Thank you so much. Hi, everyone. I'm Laleh Shayesteh, and I'm happy to be speaking with you today about intellectual property and licensing. I like to not talk from PowerPoint presentations, but just keep this conversational. So if you have any questions that are not confidential, please post them or do ask your questions as we are going along because it keeps the conversation more fun. Otherwise, I'll just go through what I will be talking about, and then I'll take questions if they are confidential. All right. So at the Office of Technology Licensing, basically, our job is to make sure that we are creating and keeping a cycle of innovation. Basically, we receive inventions, we receive software disclosures, invention disclosures, and then we try to transfer these to the industry. And then if we receive resources and money through the licensing, and when we receive money through the licensing, we put it back into research and education and reward the individuals, reward the inventors or the software developers who provided these technologies to us. We also receive a lot of funding, of course, from various sources, such as especially from the government, from granting agents, different granting bodies, and also through gifts. So, and all of that, again, goes into a cycle of innovation that we manage. You may want to ask, you may be asking yourself, what is intellectual property? And as far as I'm concerned, I have always said intellectual property is what's in between the two ears, right? So it is inventions, it is software, it is knowledge, it is business knowledge, and it is in general what you bring with you when you enter into an employment or when you're doing something by yourself. Basically, the type of knowledge that you bring to the work that you do and what comes out of it, right? What creations of the mind happen as you are doing the work that you do. Intellectual property has different forms, and I'll go through some of the ways that uh, are used to protect intellectual property. So, for example, commercial entities always have or believe they have trade secrets and know-how. How do we protect trade secrets and know-how? That's through keeping things to yourself. Now, that said, at the university, especially at a public university such as us, we don't keep trade secrets. We don't keep know-how. And why is that? It's because we publish everything, right? We are a public educational institution to do research and education. We just publish everything. Another means of protecting IP is through trademarks, which protect brands, right? So let me see. Can somebody tell me a trademark? What is it? Do you know of a trademark? Oh, come on. Somebody should know something. All right. Good job. Yes, Coca-Cola is a trademark. Coca-Cola also fits. There you go. Um, Coca-Cola is a trademark. And UC Berkeley logo is a trademark, right? And we keep that the UC Berkeley trademark rather fiercely. We are protective of it. The reason for keeping trademarks is to detract confusion in the marketplace. Trademarks are specifically made for the marketplace. And since we brought up Coca-Cola, Coca-Cola, for example, is also under a trade secret. The recipe of it is under a trade secret. The good thing about trade secrets, which we don't keep, is that they never become public. The bad thing is if somebody else, such as Pepsi Cola, right, copies or creates something very similar, then Coca-Cola cannot go after them. All right. Another mean of protecting intellectual property are through copyrights. And a copyright protects authors of original works of authorship. For example, software is copyrightable, publications are copyrightable, artistic works, dances are copyrightable. And at UC, basically, what is most copyrightable are software. And at UC, we release most software under very, very permissive licenses, such as the BSD license, which actually stands for Berkeley Software Distribution License. And another means of protecting IP are through patents. And a patent is a grant of the right to exclude others from making, using, or selling your invention in exchange for teaching it for a public. That term to exclude others from making, using, or selling is 20 years from the filing date of the application, from the first actual filing of the application. And a patent is always enforceable once it's issued. However, a patent doesn't give the inventor the right to necessarily use the invention. And I'll give you an example. Let's say that I have created an entire car. And now you have created a tire that will fit that car. Can you use the tire on my car? And you have patented that tire. Can you use that tire? Not necessarily without getting permission to use my car as a whole. But, that is called freedom to operate. And we generally work on that as well. At UC, we don't worry too much about this freedom to operate or being able to use something or not, because as a university, again, we are doing mostly research. We are not doing commercial work. We are not hurting anybody else's business. We are doing research and education work. All right. Do I have any questions yet? No? Okay. And as far as patents are concerned, you may be asking what can be patented? What is patentable? A Supreme Court ruling a long, long time ago said, and it still stands, anything under the sun modified by a human that is novel, meaning nobody else has done it before. It's non-obvious, meaning that the pieces might exist, but nobody has put them together the way you have put them together before. And they need to be useful. So, for example, you cannot create a novel mouse, a genetically modified mouse, just to feed it to a lion. That doesn't work. But if that genetically modified mouse can be used for cancer education or disease work, then it could be patentable. And finally, patents also must teach a person the term is ordinary skill in the art, but that just means a person knowledgeable in the same science area as you have filed a patent application on how to make and use the invention. If an invention disclosure has all of those being novel, being non-obvious, useful, and teaching a person on how to make and use the invention, it can be patented. It is patentable. So, since we are on the topic of inventions, I'm hoping that all of you remember when you became UC employees that you did sign that IP agreement, IP acknowledgement that says uh, if you use, while you are an employee of UC, if you're using UC funds that are being managed by UC, you're using UC resources, facilities, then the IP that you will create, intellectual property that you will create will belong to UC, will belong to Berkeley. And Berkeley is one of 10 campuses. We all belong to the regions, so that IP will belong to the regions. So um, now let's say that you have created a new piece of software that you're interested in licensing out, or that you have an invention disclosure that you're interested and you think would be of commercial interest, right? So what happens then? We have a page on our IPIRA webpage that provides a link to disclosures for, it says it is ipira.berkeley.edu. Oh, thank you. Thank you, Deborah. And we have, and you will have the chance to provide us with your invention disclosure. And the most important parts in that disclosure is we want to know who you are. We want to know who the likely inventors could be, who really helped you to conceive, to actually put the invention together. We want to know where the money came from. How were you supported to bring this invention to Berkeley, or to bring the software? Was it government funded? Was it funded by a generous donation? Was it funded by a gift? It is really important for us to know that, because for government and also for foundations and for a lot of granting agencies, not necessarily government, we have requirements that we need to meet. So each time that we receive a disclosure, if there are sources of funding aside from just UC alone, we need to provide those sources of funding with information and or acknowledgement that the IP has been created and we are processing the invention. That's really, really important for all of us. And so you may ask, when is the best time, right, to provide us with an invention disclosure? I've always said it is never too late. I mean, it's never too early, actually, to provide us with an invention disclosure. The earlier, the better. Anytime before a public disclosure. And what do I mean by public disclosure? A public disclosure is not just a publication that you provide in a journal. A public disclosure under Patent and Trademark Office's laws and the US laws can be something very, very simple. For example, let's say that I talk with I tell my husband, let's say, about what I'm doing today and about a gene I have just discovered, right? Or a pathway I have just discovered. My husband does not understand biology to save his own life. However, he's a phenomenal parrot. And tomorrow morning, when he sits with his buddies to have coffee, he tells all of them about what I had done, right? And it just so happens that his buddies understand biology rather nicely. I have just published that invention. So it is very, very important that you provide us with invention disclosures before any publication happens so we can file on them. And why am I so sticky to this publication business? It's because if an invention is published before we get a chance to file on it, then we cannot, as far as all international laws are concerned, that invention cannot be patented anywhere in the world. US still gives it 1 year of grace period. And we might think about filing it, but if somebody else has filed before we get a chance to file, because we are in the first to file world, we will not be able to file on it. So we will not likely put money into filing something if it has already been published. All right. So I'm going to stop here and ask if you have any questions before I go ahead on factors for filing and then moving ahead with the tech transfer part. All right. So once we receive invention disclosures,
Oh, sorry, I had a question. Just having trouble unmuting myself. In regards to the timing of when you file a patent, let's say you file it and you're going through the process with the school, but then you're also talking in groups, like about what you're working on and the idea behind it. You would suggest against that?
depends. So you just asked about groups, right? So long as those groups are all Berkeley groups, no problem. Why is that? It's because all of us are under the same confidentiality obligations. So if you're speaking with your colleagues at UC and all of us, belong at UC Berkeley, that's not a publication. If you start talking, let's say at a conference, problem, right? A conference that has nothing to do with Berkeley, problem. Disclose to us beforehand. Let us know when that conference is, and we will do our best to try and file an application before you go to the conference and present. Am
Okay.
I answering your question?
Yeah, it made sense to me for sure.
Okay, awesome. All right. So let's say that now I have an invention disclosure in my hands. Okay, so what do we do? It is the most important part to us, really, is to make sure that, first of all, your invention will remain with us. And another one that is very important for filing of the first application that we do or the future applications is to see commercial potential for the technology. Patent applications, from the time that the original patent application is filed to the time that a patent will issue, in the US, depending on the technology, is anywhere between $50,000 to $100,000. So if we do not find commercial interest for that technology, our group is very likely to stop prosecution or to stop continuing a patent application anywhere along the line. That's because unless there's commercial interest, unless there's someone as some entity to license the technology from UC, a patent application becomes an extraordinarily expensive publication. Given that we use research and education funds to do filing and applications, we are really, really careful as caretakers of money for UC on what we file and how far we will do the filing until we receive commercial interest. And if we don't receive commercial interest, we are not very likely to move ahead. Since I talked about patent filing in the US, any filing outside of US is going to be about $100,000 from the time we file to the time we receive a patent. So that's even more expensive. All right. Where we have patents, depending on the technology, we think about the strategies on filing, whether in the US or outside of US as well. Where we have, for example, pharmaceuticals, chemicals, or biologicals, we do think about filing outside of US because our objective would be monopoly, right? A drug from, let's say, if we had a drug on our hands, it is really important if we do have a licensee that, for example, that biologic, that drug, is going to be protected all over the world. However, for example, if we have software and we want to put a patent behind the algorithm or method of using it, the objective is to just make sure that all competitors, right, have a chance to play in the field, not necessarily to have a monopoly around the world on a software, because by the time a software or technology that has to do with software issues, it's like 10 years from the time of filing. And in 10 years, maybe the software is not even important anymore. All right, Chris has a question. Could you tell us what the internal process for assessing commercial interest is? That's a really, really good question. Actually, so the question is, I'll repeat it just because this is being recorded. Could you tell us what the internal process for assessing commercial interest entail? The very first filing that we do, right, is an inexpensive filing called a provisional application. And a provisional application is a placeholder with the U.S. Patent and Trademark Office. Basically tells the patent office, hey, I have this invention. We're kicking the tires on it. We'll let you know in about 10 months whether we want to go ahead or not. It's not expensive. And therefore, our barrier to filing the very first application is really, really low. The most important part for me and for us at the office is the question right back at you. The invention disclosure will ask us, please tell us what you think, as you're describing this invention, which commercial entities will be interested in this? Can you tell us about this, right? And usually the inventors write a lot in this field. Hey, this is so important. All these companies, go to GSK, go to this, go to that, or go to this big architecture company. They will all be interested in this. If I hear something like this, and if we understand that our inventors are excited about this technology and they believe that this could have commercial future, our barrier to filing the very first filing is very, very low. I almost always file that very first filing. I hope this answers your question, Chris.
And
All
when
right.
you say the very first filing, how many
Uh-huh.
different stages are there when it comes to filing?
Okay, so a patent application goes through a series of filings. The very first filing is called a provisional filing that UC does. And that provisional filing is just like I let you know a second ago. It is a stakeholder with the patent office that says, hey, patent office, I have this application. We're kicking the tires on it to see if there's commercial interest. By the end of the year, by the end of, around the 10th month or so, if nobody has come around or if nobody from the lab themselves or none of the inventors themselves want to start a startup based on that, we'll be knocking at the door. Hey, inventors, how are you doing? What's going on? What's happening, right? The next stage that UC usually does is called an international application. If we see that there is huge interest, if we see that the inventors are passionate or let's say a publication that they were planning to publish, right? The paper is just about to come out. It is very likely that we will file that international application. international application lives for 1.5 years. It is the way I would like to describe it. It is that same provisional application on steroids. So between the provisional application and PCT application, patent, the international filing, and we have had 2.5 years for a commercial interest to come along, right? By then, if we have not received any commercial interest, we will let it drop. But since you asked, the next filing, if we decided to go on, if somebody wanted to reimburse us for the filings, it will be a national filing. That is when an application actually goes into different jurisdictions, countries. So for example, after the international filing, it will go, we would like now to go into US, we would like to go into Europe, into Japan, into China, right? And that is when the application prices, right, patent application prices start to soar rather rapidly. And that is the time that these applications actually start to get examined, and we go back and forth with the examiners until we are able to get a patent. The whole process, depending on the technology, depending on its novelty, can take anywhere between about 4 years to 10 or so. And so we will stop at the 1 year mark if we really haven't seen commercial interest, nothing absolutely has happened, or people have moved on, or go into the next one, which is the international filing. And then beyond that, it would be really hard to push us to file the national filing unless either there is commercial interest or somebody from their unrestricted funds wants to pay for it. I hope that answered your questions. Deborah, thank you. She already put everything on the assessment of inventions and also the patent application flowchart.
And if the school suggests that it doesn't want to pick up and continue the filing process, and then someone else was, like let's say the inventor was still motivated and wanted to pick it up himself, would he then continue on with the school still on board, or does the school then decide to leave it to the inventor?
It has nothing to do with the school, actually. So remembering that inventions, those disclosures and inventions belong to Berkeley, it would then be our decision, the decision of our team on what to do for the next steps. Let's say, Alan, that you were the only inventor, right? And I'll give you two different examples of what will happen. All right. In example number one, government funded this or a sponsor funded this. What we will have to do, government doesn't say if you don't want to continue with it, to give it to the inventor. If we don't want to continue with it, we will give it back to the government, and we will let the government know that the inventor is interested in it. Alan, go get it from the government, or we will provide you with the name of the government. I'm happy to provide you with the name of the contracting officer at the government that you can reach out to and see if you can get it from the government, get the rights from the government. Choice number two is, let's say there was no funding. This was just UC itself, let's say UC-based funds, or you just thought up of it at UC. You still use UC time and resources and facilities. So it is only you're the only inventor. Okay, and UC decides not to go on. Then what happens, right? If you're still interested in it and you have unrestricted funds, you can pay for it through your unrestricted funds. If you're able to license it at some point and that license brings back revenue, the first money that goes in, it will go back to replenish your unrestricted funds. If not, and you really want to have it for yourself, no problem. We will give it to you. We will say, okay, UC stops. UC will give this to you. However, you will never be able to work on this technology at UC because that will bring a conflict of interest. So Most people usually choose door number one, that if you have unrestricted funds, that you will pay for it yourself. If we gave the invention to you, by the time you want to pick it up, it's then a very, very expensive patent application filing and prosecution.
Gotcha.
All right. And so once we have, once we, let's say now that we are done with the patent filing and application, let's say we have interested parties. What do we do then? Right? Our interest is to transfer that technology to somebody, to an interested party commercially, right? And for that, we have different types of agreements. We have letter agreements, option agreements, and license agreements. So license agreement to begin with is not the first choice at all times. And why is that? It's because the technologies that we have are really, really, really early stage. We are a university. We are not in the business, in a commercial business of creating a technology and seeing it until it becomes a product. We are in the business of doing research and education. So when we are creating technologies and trying to license them out, probably the very first agreement that comes out of the university will be what is known as a letter agreement. And a letter agreement is a very, very simple agreement between us and the entity that is interested in taking the technology and bring it into commercial marketplace, right? And usually, the entities that do this are startups out of our own labs. And startups, by definition, don't have a whole lot of money. So we are not going to be trying to get a lot of money out of a startup. Instead, what we will try to do is to work with our startups or these startup entities to take the technology out of the university. A startup letter agreement that we have is a very, very, very simple one-page document that says, hey, this agreement is between the university and you know, the startup, for a very small amount of money for a period of 6 months or so. You're allowed to take this technology in-house meaning to your company, to your startup, work on it and see if it works in your hands, see how it does with you. And then from there, if you have further interest, come back and talk with us and we will go into the next stage of the agreement together. Startups really, really like these letter agreements because the letter agreements are not expensive. And they're also very helpful to the startup because startup now has this document in their hands that says, hey, Berkeley has promised this technology to me. Look what a great technology it is. VC, you know, especially when they go to venture capitalists, like VC, look at what I have in my hands. Would you be interested in this? Or they can go to, if you're familiar, if my audience is familiar with small business grants to SBIRs and STTRs, when they are applying for these non-dilutive grants to the government, they tell the government, hey, look, you know, we have this promise from Berkeley to have this technology. So the government will be happier to give them funding. And one of the things that our office has always done is if our startups or licensees are interested in filing for SBIRs and STTRs, we always write letters of support for them, which then looks really good as far as the government is concerned. And the government will be happy to give them funding. All right. And then let's say that the startup has been, and then that the entity has been successful. They come back and they ask now for an option agreement, probably. An option agreement also, to me, is a letter agreement that is 20 pages long, right? It allows the company to have the intellectual property in their hands. They're not allowed to sell it. They're not allowed to sub-license it. They're not allowed to offer it for sale, but continue to use it in their hands and see if they like it. It is for a little longer period of time, for example, for 1 year. It comes with more requirements from the company. We need to have a basic, very basic commercialization plan for it, and then go from there. Usually, startups are interested in letter agreements because they're very, very simple documents. If we have a big company as an optionee, then they're more interested in option agreements, which is perfectly fine. And finally, let's say that the entities have been very successful. They're now coming back. They have found VC funding, and now they come back to us for an actual license agreement, which is always, wonderful to our ears. And the license agreement, for a license agreement, we will need, our office will need a commercialization plan, meaning the same plan that a company will be providing to the VCs, or that they will have as a plan for themselves to bring a technology to life, to the commercial marketplace. And why do we ask for a commercialization plan? It's because we get all of our money, well, most of our money from federal government and state government and taxpayers, such as myself and you guys. We all want to know how the technology is going to see the best light of day. We are mandated by the government to make sure that all of our technologies do get the chance to be commercialized. And so we always ask for commercialization plans. That is really important, extremely important for us from any of our licensees. And we will keep the licensees' feet to the fire on the commercialization plan. Once we have a commercialization plan, then we will enter into a term sheet, basically just discussing the financial terms of the agreement with each other. And those financial terms include license entry fee, license maintenance fee, payment of all the patent costs, and then royalties, sub-license fees and royalties. And hopefully, we come to an agreement with each other, and then our office, somebody like me, will put pen to paper, will produce the license agreement and provide it to the licensee. We will negotiate the license agreement, be done, and then hopefully everybody will walk away happy, and commercial success will happen. One of the important things that I wanted to bring up actually is that we are one of the extraordinarily few entities in this entire country that has all of our agreement templates actually online. So we are very transparent about our licensing and about all of our agreements. The templates, like I said, are online, but the license agreements themselves that we have with various entities are confidential, of course. But our letter agreement templates, our option agreement templates, and our license agreement templates are all online. So the only things that we really will have to negotiate are just the numbers that have to fill up the document, or if a licensee happens to have a small heart attack about any of the subject matter in the license agreement that we need to discuss further. Otherwise, license agreements are very easy to enter into, I hope, once both parties have a clear plan of how to enter in them. We enter into licenses. We have a different strategy for every license, and usually enter into licenses with that idea in mind, right? We like to enter into most licenses with our licensees as non-exclusive licenses, depending on the technology, right? So for example, for research and development licenses, if an entity is interested only, for example, let's say we have a battery technology and the entity just wants to make batteries and sell them, we prefer to enter into a non-exclusive license with that entity for research and development purposes, non-exclusively. But we also enter into exclusive licenses, especially for the different technology styles. So for bios, pharmaceuticals, or chemicals, we do definitely enter into exclusive licenses because the entity is going to have to spend significant resources to reach the market. Drugs cost, I don't know, $300 million before they can enter into the marketplace. And definitively, the licensee does not want a non-exclusive license. We also enter into licenses, keeping in mind different fields of use. Fields of use is uses that a technology could have. So, for example, a compound, a drug can be used in various applications, right? It can be used for research, at which time we will provide it as a non-exclusive license. But it can also be used as a diagnostic or a therapeutic. So we can enter into an exclusive license for diagnostics and another exclusive license for therapeutics. These would be to the same entity for different uses or to various entities. Maybe somebody is only interested in diagnostics and somebody might be interested in therapeutics only. All right. And finally, I wanted to bring up that UC has a very robust innovation and entrepreneurship ecosystem. We have a number of resources for educating entrepreneurs and advancing startups. And I believe Deborah is going to help me put the I&E resources up on the webpage so everybody will be able to access it. If you have any questions at any time, really from any of us, you can always reach out to IPIRA@berkeley.edu or OTL@berkeley.edu. And one of us will always be there to answer questions. And with that, I'm going to stop and ask if I have any questions.
Laleh, would you like me to stop recording?
Sure. Let me see.
Deborah,
Sure.
is it okay to have these questions on the recording?
That's perfectly fine with me. So let's continue the recording, but please don't ask me confidential questions. If you have confidential questions, don't ask. But yeah, no problem to continue the recording. Thank you so much, Deborah, for bringing the Entrepreneur I&E webpage. All right, Candice, what factors do you take into account when setting the equity and royalty amounts in a license? What a great question. All right. So to us, we bring in a term sheet, and a term sheet for a license has a lot of factors in it, right? It has a license issue fee. It has license maintenance fee, sub-license fees, royalties, equities, and repayment of patent costs and milestones, right? Depending on the industry and the type of technology we have in our hands, right? The very first step that we take is ask for that commercialization plan. The commercialization plan will tell me, or somebody like me, there's 5 of me in the office, will tell us exactly what it is the company is interested in and how it is they're going to get to the commercial marketplace. Is this a thing there? Is this a product? Is this a service? Is this a method they're trying to do, right? And based on that, and also a company, because of their commercialization plan, will always know what it is and how much of the market they are trying to capture, right? So if this is a $300 billion market, or is this a $30 million market that I'm going to capture, right? Now, we take all of those factors, we look at the commercialization plan, and then there is one entity that we speak with that helps us with numbers, as they are a VC that work only and only with universities and only put money into universities. And they help us figure out the numbers, or the closest numbers that we are supposed to be asking for license in the same technology area, and what the past 5 or 10 years in this technology area has looked like. Based on that, we bring in the numbers in a term sheet to our potential licensee. Now, all of the numbers that I provided are like dials in a whole system, right? For example, I'll ask for a 5% equity in the company for an undiluted portion, let's say undilutable until 4 million. But you say, hey, I want to give you more money upfront. Then we can bring down the amount of equity. Usually when licensees come along, especially if they're startups, a startup doesn't have a lot of money, and what money they have, they want to put through for their research work. They don't want to they don't want to give the university all of their money. So UC goes really easy on startups in the front end of a license agreement. But then we backload the license. We do ask for royalties, and we do ask for the equity in the company, because especially the equity, and we're really interested in that because we want to have if you're successful, we want to be successful too. We are happy to not take a whole lot at the beginning, but we are happy. We will be even more happy if you're really successful, that success will be meaningful to us too, because we bring that money back to the inventors, to the developers, and back to the university. A very large portion of that money goes back into university for research and education. Candice, did I answer your question?
Yes, that was super helpful. Thank you so
Awesome.
much.
Awesome. Okay. But if you have further questions, let me know. All right. And Chris asks, is the IPIRA process or startup pathway different for staff compared to faculty, postdocs, and PhD students? Nope. The pathway is the same, because once a company has started, it has started, right? And I just want to make sure that we know faculty may be founders in a startup, but faculty will not be an employee of the startup. If faculty becomes employee of the startup, then they're no longer employees of UC. And that's that. We don't negotiate a license with our faculty. We negotiate a license with the startup or with the company. The process is the same for everyone. I have negotiated with students, I have negotiated with postdocs, I have also negotiated with staff, and I have negotiated with companies that faculty have been founders on. Okay, other questions?
Yeah, mine might be a little bit more back when it
Okay.
comes to the patent process. So if you have an invention in mind and you believe it's patentable, and the school provides the patent lawyers to make the patent, let's say this technology, after you disclose it, it can be made in several different ways. So you want to make it as general as possible, so that you even though there might be other ways of making the same invention, you have it under the patent. Does the patent lawyer from provided by the school go into doing the research and how making this patent more, I guess you could say, general or solid, or is that something that the inventor himself has to put a lot of focus into?
So, let me step back, and that's a very good question. So, the patent lawyers, we take counsel, the patent lawyers from our office hires them, and our office will pay for them. The What I've always said is that we in a patent application, a patent application is like a deed to a house. When I go house shopping, I go to a street and I'm asking for every house in that street, on that street, right? And ultimately, I have to go back and forth and back and forth, and I ultimately end up with my house. It's the same with a patent application. When we write a patent application, we ask for the entire field, right? But then we have to ultimately end up on a single claim, right? Or as many claims as we go back and forth with the examiners and are approved. Your question would have been really awesome 20, 30 years ago, because at that time, anybody could ask for a huge, meaning ultra broad patent application, and then end up also with broad claims. Today, that's not the case. We can ask for a broad application, but I will have to see in that patent application very crisp claims, because at the end of the day, the very first thing that happens when a patent application goes to the patent office, and once we have continued to do that application, the examiner comes back and says, you have too many inventions in this application. Figure out which invention you want. You're only allowed to take one invention. So, and that's how it's going to end up, invention by invention, so long as there is a commercial entity who wants to pay for them. Also, if we file a patent application that is so broad, not only are we creating what I like to call a poison pill for the entire communities, like nobody else is going to be able to claim them. Remember that you yourself will not be able to claim them in the future too. So let's say that you have not created aspirin, which is really good for headaches, and I go out, but you say, in your patent application, this aspirin is good for any disease in a human. Okay. So I pick up the aspirin the next day and I see, oh, it's really good for my skin condition too. I can't claim it, but neither will you be able to claim it, because you already provided in your broad application that it is good for all disease. So there is a fine line that we can walk on what to claim and what not to claim. Patent attorney will ask the inventors, what else do you think this will be useful for? And your invention disclosure also asks that. You will provide, hopefully, the answer to those questions. You're best placed to do that. Other than that, then we let the patent application fly. Does that answer your question?
Yes, thank you.
Awesome. All right. Have another one. Does the money that you see recouped go to the college that originated the invention or to the general fund? If we recuperate money, so if we get licensing revenue, the first part goes, we need to make sure after all the patent costs have been paid and the licensee is responsible for it anyway. The net revenue, so after all the costs have been gone, the net revenue gets divided up. 35% gets divided between the inventors. 15% goes to the department of the inventors, and 50% goes to the VCR, goes to the Vice Chancellor's office to use for further research and education. All right. Any other questions? Oh, wait a minute. Oh, awesome. Thank you. Okay. Any other questions? All right. No questions. So if you ever have any questions, please, you're always more than welcome to send me an email directly, and I'm always happy to respond.
Great.
Oh, sorry. And I wanted to thank you all for your time.
Super. Well, thank you, Laleh, for sharing your expertise, and for Deborah for providing all that information in the chat. And we appreciate your joining us today. And if you do have a minute, we'd appreciate your taking the survey. It will appear once you've left the room. And as Laleh said, if you have any questions, please don't hesitate to reach out to anyone on the IPIRA team. All right, folks, enjoy the rest of your afternoon.
Yeah. Thank you. Thank you.